You are Mr. Gurley?
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, Judge. On February 27th, 2025, at approximately 11 p.m., the officers observed a vehicle repeatedly fail to drive in a single lane, nearly striking two other vehicles as well as the inner curb. A traffic stop was initiated. The officers made contact with the defendant, the driver of the vehicle, and observed slurred speech. DWI task force officer arrived on scene and made contact with the defendant, who had just exited the vehicle, and observed a visible loss of balance, red glassy eyes, slurred speech, and an odor of an alcoholic beverage. The defendant stated he believed he was on Gulf Freeway and El Dorado Boulevard when he was in fact far away from East Sam Houston Parkway and Genoa Red Bluff Road. The defendant admitted to coming from a business meeting where he consumed 2 old fashions and standard field sobrieties were conducted. HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant refused to provide a specimen. A blood search warrant was signed and executed.
May I address the court on that, please, Your Honor?
Sure.
So in terms of, the accuracy, I guess, of the DIMS report and the accuracy of the summary here, I take great affront with what the police officer alleges here. We do have the video cameras right now. We have the dash camera video that shows that what the police officer is alleging is not nearly what actually happened out there at the scene. As he approached the vehicle, we can see when the dash camera kicks on, he's in excess of 1,000 feet away. So it's not like he's been following him for a long period of time and that there would have been a lot covered before the camera kicked on. But there's not even 2 vehicles anywhere near the vicinity that he could have even possibly nearly run into. There's only 1 vehicle and he's within his lane and he isn't nearly striking that vehicle. As far as what actually leads to the stop, we see in the video that
I can't get into the video.
Okay.
Now, this is a probable cause hearing, and I have to give them the opportunity to respond. I can't imagine that they've already seen the video.
Sure. So I've addressed these issues with the state thus far, and I know that they've set it for a state eval to evaluate these cases. I just personally have an issue, and I've had some experiences where police officers lay out what's obviously valid probable cause for this purpose,
Obviously.
but is not accurate.
Mr. Stewart, I'm happy to set it for like a formal probable cause hearing in like a week where we give them time to look at the video, research case law, due diligence. But here now, when you start getting into video, you start getting into evidence, I can't possibly, I need to give them time.
Yes, sir.
Because it's only fair.
I understand. So I understand that the 4 corners of the DIMS and what the state has alleged here certainly constitutes PC. I understand.
Sure. I mean, we have, weaving,
Right.
justifies the weaving by saying he's almost hits this in there. As a practical matter, theoretically there's probable cause. As a practical matter, is it beyond a reasonable doubt?
Sure.
Maybe not. I don't know.
understand.
But, we can always set up for a hearing and I'm always ready to do it. But I got to give them time.
Okay.
You
So I'll allow the state to do their eval that we've discussed this morning. I spoke to Ms. Balance about that this morning. And maybe that resolves this and maybe we don't need to have any kind of hearings or.
And I'm happy to give you whatever date you want. If you want to do a week, 2 weeks, as long as you're okay with it and however long you want to.
Absolutely, Judge. We would just need to speak to the officer and do.
Sure.
Sure.
Right. Okay.
So if we want to do a couple of weeks, could we waive Mr. Gurley's appearance at that?
Yes.
hearing? Okay.
Yes. But I have to do conditions. Now,
Yes, sir.
did you say, look up his NCIC, any prior?
Virus and his license eligible, Your Honor.
Okay. Mr. Gurley, for now, I'm going to find that there's sufficient probable cause to go forward. I am ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. If I find that you're consuming alcohol or illegal drugs, then I'm going to put you in jail. Do you understand? Sir. You're not to do anything don't pick up any new cases. Don't be a danger to my community. I'm not asking for much. I just want my streets safe. That's it. I'll have you go to Ramona, sign a reset. You'll get with Felicia for your bond conditions, and then after that, you're free to go.
Thank you, Your Honor.
Whatever date you want, Craig.
Yes, sir. Thank you.
Okay. Have fun, guys. You were Mr. Samuels.
Yes, sir.
Sir, you're charged with failure to identify oneself through a peace officer while being a fugitive from justice. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 28, 2025, the officer was dispatched to a suspicious person call on Montgomery Road in Harris County, Texas. The officer arrived on scene and was informed by the caller that there was a male at the above location that had a warrant and that he was sitting on the steps in front of the apartment. When the officer arrived, he did not observe a male on the steps, so he knocked on an apartment and the defendant answered the door. The officer told him he received a call at the location and asked him to identify himself. The defendant stated his name was Lavante Samuels with a date of birth of December 7th with no year given. The officer had officers on scene run the defendant NCIC, TCIC, and nothing came back. The officer asked the defendant again for his name, and he informed him the same name. An assisting officer on scene informed him that the defendant was the wanted person, so the officer detained the defendant. The officer placed the defendant in handcuffs and thoroughly searched him before placing him in the back of the patrol vehicle, and was shown the defendant's mugshot, and asked the defendant again if he would tell me his correct name, and he proceeded to tell the officer that I already got it. So I asked for a unit with a mobile AFIS, and the officer used the mobile AFIS and was waiting on the defendant, who then stated his name was Lavante Samuels. The officer then had dispatch confirm the warrant, and the defendant stated that he had told him the wrong name because he knew he had a warrant. The warrant was confirmed, and the officer took the defendant into custody.
So you had an open, what, felony warrant?
I'm trying to find what it was. It was an AFM warrant, an assault family member. I'm trying to see where it's.
It's a felony warrant.
It's a felony warrant, Your Honor.
Mr. Samuels, I'm going to find that there's probable cause to go forward with the case. I'm not putting any conditions on your bond. Just be careful. Don't pick up any new cases. I'm going to protect my community. If I find that you pick up a new case, I'm going to put you in jail. Do you understand? No more PR bonds. Do you have the ability to hire lawyers, sir?
Yes, sir.
Okay, I'll have you fill out an application. I'll have Deputy Miranda give you one. I'll take a look. I'll have you sign a receipt with Ramona. We'll have you fill out the application. I'll take a look, see whether you qualify.
Good morning.
Your iPhone, is it Shake?
Yes, sir.
Sir, you're charged with 3 cases. You're charged with terroristic threat of a family or a household member. You were charged with assault of a family member. You were charged with interference with emergency request for assistance. All 3 of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Can I say something or no?
About the case, or do you have a lawyer?
I don't know. Yes.
I'm sorry?
About attorney, and I need to discuss something, sir.
You are an attorney?
No. I need attorney. I need attorney.
I need hair. We'll talk later. Let's do probable cause first. You have the right to remain silent.
Okay, yeah.
Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir. On February 23rd, 2025, in Harris County, Texas, the officers were dispatched to a threat to life call. Upon arrival, the officer met with the complainant, who stated that the defendant is her husband. The complainant stated that the defendant and her got into an argument, and that the defendant stated, "I'm not afraid of the police. I will grab that knife and cut your throat." The complainant then stated that the defendant had, on November 16th, 2024, assaulted her. The complainant stated that the defendant grabbed her by the top of her dress, causing scratch marks, and punched her in the chest, causing bruising. The complainant stated that she attempted to call 911, but the defendant ended the call.
Sorry, patience.
The terrorist threat was I'm going to grab a knife and cut your throat. Okay. Mr. Sheikh, I'm going to find that there's sufficient probable cause to go forward with your case. Do you have the ability to hire a lawyer?
So this also is the attorney. Federal money.
I'm not going to listen. You have the right to remain silent. Exercise that right. Anything that you say, they're going to try to use it against you to prove guilt. So what I can have you do is I can have you fill out an application. I will take a look at it to see whether you qualify. We don't give appointed lawyers like it's candy on Halloween. You have to qualify. And if you do, then I'll take a look. But I need you to fill out everything. As it stands now, I am ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. You are not to go within 200 feet of where this person lives or where this person works. Do you understand? Do you see whether a order for protection has been entered in this case? Guys,
Let me see.
And Judge, the DVD prosecutor is on the phone.
Oh.
There he is.
that's
Yes, I was able to make contact with her. I'm not sure what the discussions were beforehand, but we're gonna be asking for no contact with to keep the resident, whatever the residency restriction is.
she does not want to have contact with her. Okay.
And I don't see a protective order in place.
I'm not AFM there.
Is there one in the
Yeah,
But I'm going to also do one on the terroristic threat.
yes, Judge.
I want you to understand something and take me seriously when I say this, that when I mean no contact, I absolutely mean no contact. I don't care what's going on in your life. I don't care that you need clothes. I don't care that there's a child involved. I don't care that you need to go get the car, whatever it may be. No means no. And if you violate these court orders, the state can and probably will file a violation of a protective order against you. That is the capital murder of misdemeanors. Do you understand? I am now entering in what's called a magistrate's order of emergency protection on the terroristic threat. This is a court order that identifies the complaining witness as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? This is what I'm saying, that if you violate this order, they can file additional charges against you. Now, Deputy Miranda will give you an application. I'll have you fill it out. I will take a look whether you qualify. Anything else you want? Oh,
No, Judge, I'm no contact.
so can you also file the no contact and no weapons so that it outlives the, okay. Do not leave until you sign our additional bond conditions.
Yes.
Okay, please. Good morning, Ms. Stair. Ma'am, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. Officers were dispatched to Fairmont Parkway in Harris County, Texas, and the defendant was arguing with her husband in the parking lot and got into the car and drove off, nearly hitting him and causing him to fall to the ground. Witnesses called the police, and officers found the defendant in her vehicle near the exit with the car and drive. The defendant ignored the officer's request to turn the car off, and officers noted slurred speech, red eyes, and unsteady balance, in addition to an odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 4 out of 6, and the defendant refused the remainder of tests and was transported to JPC. The DIC was read and the defendant refused. A blood warrant was signed and executed. During an inventory of the vehicle, the officer located 2 stemless wine glasses. The glasses contained a small amount of a red liquid smelling of an alcoholic beverage and showed recent signs of consumption. The defendant's purse was located in the front passenger seat and was stained with the red liquid matching the hue of the liquid in the glasses, still wet and smelled of a fruity alcoholic beverage.
There, I'm going to find that there's sufficient probable cause to go forward with the case. I am now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I am now also taking away your privilege to drive. You are not allowed to drive. Do you understand? If
Yes, sir.
I find that you do, I will revoke your bond, put you in jail, and I'm going to make it high. You will be signing an affidavit with me today, promising me you're not going to drive. It doesn't matter what you need to do. Do you understand? Not only that, I'm now placing a restriction on your license that you are not allowed to drive any vehicle that is not equipped with an ignition interlock. I send this order to DPS so that every single officer in this state knows you get pulled over, they'll look you up, they'll see that you need an interlock in your car, and if you're caught driving one that doesn't have one, they will take you to jail. Can you run her NCIC, please?
Yes, Judge. So she only has the one prior from 2000 at a 45 DWI, no other prior DWI.
Do you have the ability to hire a lawyer, or would you like to apply
I
for?
would like to apply for a court appointed.
Okay, Deputy Miranda's going to give you an application for an appointed lawyer. I'll have you fill it out and I'll take a look to see whether you qualify. I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Ramona where you will sign a reset. You will get with Felicia if your bond conditions. I don't know if you have a problem with alcohol or drugs. If you do, now is the time for you to address it. Because if I see it becomes a problem, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand? Okay, come on.
Can I know the last name?